Greetings again. Today we're going to complete the course with Lesson 30, the appeals process. This is where the fun really begins, because this is where the government begins to pay, and pay in big bucks, if they want to proceed forward now to the Supreme Court of the United States. In the appeals process, there are several factors that we need to go over, especially the rules that govern the appeals process, the historical background of the appeal, why we have appeals, what makes us different in our appeals process than, say, the Chinese, the Japanese, or the Russians, what the technical rules are, and what kind of standards you're going to be held to in the appeals process. So to begin, let's go back to the beginning of the course and remember that we started at status, and we said, okay, what kind of status do we have? Are we the type of person, are we on the right side of the issue or not? And that type of person was, are we a juristic person or are we a common law citizen? If we're a common law citizen, we're talking about rights. Then we went to the scene of the crime, and we progressed through the jailhouse scene, and then we went through 2 or 3 hearings, and we got to the trial, and we went through the trial and we were found guilty by the jury. And then we went through the sentencing process, and the judge said, I'm going to put you in jail for 5 years, and we're going to fine you $10,000, and this brought you then up to the appeal. How do you get an appeal before a higher court, and then from that court to the next higher court and on up the line? And that's what we're going to talk about today, and that's where our real defense begins, is with Lesson 30 and not with Lesson 1. We staged each and every procedure that we've gone through so far with one goal in mind, and that's to qualify this case for the Supreme Court of the United States. Now, if we've done our homework correctly up through Lesson 29, and we're ready to go to jail, we're ready to do whatever is necessary, we may actually physically be in jail, and this appeal may be made by one of our fellows on the outside. And that's the reason for Lesson 29. You must be prepared for jail. Because if you go to jail, you will not be able to put your appeal together. That's one of the anomalies of our judicial system. Number one, they've compelled you to get a licensed lawyer. And if you elected not to get a licensed lawyer, now you're cut off from the outside, you're made a ward of the state, you're on the inside, they have total control over you, and you cannot get in or out of that prison any paperwork that they won't let you get in and out. So therefore, you're at their mercy. This is why it's so important, at least we feel, to have some fellows on the outside, a computer, and a game plan. In other words, everything you do, if you've done it pursuant to the standards that we've set down here, that we've practiced with, and that we've experienced, and that we've actually performed in the last 5 years, you're not acting as a matter of accident. Everything you've done is a matter of purpose. That it went step 1, step 2, step 3, step 4. So let's start now for a moment and let's think about the sentencing. When you went into the sentencing hearing, if you handled the sentencing hearing at all, you would have maybe given a 20 or 30 minute speech. You might have said, well, this is why you shouldn't put me in jail. And it's at that sentencing hearing that, number one, you present your stay of execution pending appeal, and you present the notice of appeal if it's necessary pursuant to your rules. Now, the notice of appeal and the stay of execution pending appeal are 2 separate motions, so to speak. First of all, you're appealing to the judge to give you a stay of execution so that the appeals process can run out. As an example, you'll notice that all of the abscam defendants were out of jail pending appeal. All right? They went through their trials, they went to the sentencing, and they were sentenced to whatever period of time that they were sentenced to, and then they went before the judge on that very day, and they presented their notice of appeal and their stay of execution. The purpose being, please don't hang me until we determine whether or not my appeals can be perfected. And this thing of perfecting your appeal is simply to bring out the constitutional issues and or the trial defects that would reverse your conviction or grant you a trial de novo or a new trial. Now, let's say I went into a sentencing hearing, and I'll just give you an example of the way I handle it. Sometimes I think that if you just tell a fellow a story, then you can relate better to that and follow along in your own mind. I had been convicted for not having a driver's license, registration, or proof of insurance. All right, now the sentencing can take place that very moment if, in Idaho, you waive your right to the mandatory 24 or 48 hours. I've forgotten exactly what it is. I think it's 48 hours before sentencing. Now, there's a reason for that 24 to 48 hours, and that's to give me an opportunity to get out of the courtroom, go back to my office, and write up a stay of execution and a notice of appeal. All right? So the judge will ask you in a petty misdemeanor if you'd like to waive your right to be sentenced in 48 hours or whether you'd like to be sentenced today. Now, I always take the 48 hours. Then I go back and I write up the stay of execution pending appeal. Now, once I've got that stay of execution underway, and I think I have one here, or at least I have I'll dig that out here in a few minutes. The notice of appeal, this depends upon the judge in Idaho, because we believe that the rules call for the stay of execution first, and that the judge should act upon that, and act upon it for 42 days. But we found from experience that some judges will throw you in jail if you don't have your notice of appeal right there in the courtroom on sentencing day. So it's for that reason that it would be to your best interest, or in your best interest, to have your notice of appeal, which is simply a couple of pages, and we'll cover that here in a few moments, along with the stay of execution. Now, in this particular case that I'm thinking of, I presented the stay of execution, and here's your sentencing, and I spoke for about 30 minutes and told the judge that the purpose for this trial is to test a constitutional issue. And that in order to test this constitutional issue, it's necessary for me to break the law, to break the statute. And I went through this Ashwander versus Tennessee Valley Authority, the 7 rules, remember, and I'll cover those again a little later, but those 7 rules that we covered in Lesson 13 and talked about qualifying our case for the Supreme Court based upon their standards. So I talked to the judge there and said, well, I'm not a criminal, and I don't think that you should sentence me to a long period of time in jail, or that you should put any excessive fines upon me to set any lessons, or to try to show the community here that you're really going to deal harshly with people with no driver's license, registration, and proof of insurance, because there is no omission on my part. There's no malice or willful intent. This is a good faith effort to test a constitutional issue, and I've presented my facts and I've presented my issues of law to the court, and the court has simply found me guilty of being black and riding the front of the bus. And so the judge, when we got through, said, okay, here's what I'm going to do. I'm going to sentence you to $200 fine, going to sentence you to 35 days in jail. I'm going to suspend the $200 fine, and I'm going to grant your stay of execution, Mr. Gordon, pending your appeal. Now, that particular judge did not require me to have the notice of appeal right then and there. And there's a reason why I don't want to file the notice of appeal right there at the sentencing hearing. And that's because Rule 54, which is what we're going to talk about here in the rules, says that when you file the notice of appeal, you have 14 days with which to file the brief in support of your notice of appeal. Well, you can stretch your entire appeal process out here in the state of Idaho to 54 days. And here's the way that works. If you were sentenced on, let's say, June 1st, it would be July 12th would be the 42nd day. You have 42 days to file your notice of appeal. Then from the time you file your notice of appeal, you have another 14 days with which to file the brief. So the entire appeal and brief in support of the appeal would give you 42, and 14 is 56 days. But if you file your notice of appeal on the first day, that is at the sentencing day, then you have 14 days to get your brief in and shut you down, and you lose 42 days. And you may need 42 days of time. Now, depending upon the judge that's involved, you need to play your cards wisely here. Here's a case that's like playing chess. You want to move your men according to the way your opponent moves his men or her men. So here's what I would do. Let's say the judge says, okay, we're going to sentence you, and you ask the judge, now judge, if you sentence me today, will you grant me a stay of execution pending appeal? And if so, will I have to file the notice of appeal today? The judge should give you a civil and an intelligent answer and say, well, I would require that you file the notice of appeal today if you want me to consider a stay of execution pending appeal. In that case, you know then that this particular judge is going to require you to file that notice of appeal. That's why you have it right in your briefcase. It's right there. If, on the other hand, the judge is more inclined to say, well, if you have a stay of execution with you in writing, if you'll serve it on the court, I'll grant you the stay of execution. And they'll typically do this if you've been in the courts a lot of times and they know you. Now, in my experience, I've never had any problem getting a stay of execution pending appeal without the notice of appeal right then and there, but I always have it in my briefcase just in case. Now, once that's out of the way, whether you're in jail or not, the appeal process must be done pursuant to the rules. And in the state of Idaho, it's under Rule 54 of the Idaho Criminal Rules. And we'll cover those criminal rules in a moment, but I wanted to give you a little more background as to what this appeal process does for you and why you've worked for 29 lessons now, gathering information, putting it between your ears, learning to write motions, practicing dialogue and cross-examination and watching trials, because everything you've done up to lesson 29, it is going to seem to you is for nothing. And I think that's why so many people coast to coast think that the courts are really just an arm of the executive branch of government, a bunch of commie pinko fags who are just there to steal your rights and violate the Constitution and to refuse to adhere to the highest law of the land. I don't believe that for a moment. And my experience has shown me just exactly the opposite, that the courts are, for the most part, anything above the magistrate's level, are relatively ready, eager, and willing to listen to your major federal questions, your constitutional rights, and that they will uphold those rights, and that they will protect you from the executive and the legislative branches of government, but they don't want to listen to frivolous arguments from fools and housewives who don't know how to walk into the courtroom and even talk with gum in their mouths. They just don't want to do that, and in some regard, I don't blame them for wanting to do that, because law is called a science, and science is knowledge, and knowledge is something that you either have or you don't have. Now, you could understand why a pilot, for instance, in an airliner, might get a little short with his co-pilot if his co-pilot had never flown an airplane before. You know, you don't want a first-timer sitting in the right seat, sitting there, and you're flying the airplane to say, hey, take over for a minute because I want to go to the bathroom. And, well, now, what do I do here? Should I hold on to this wheel, or do I push any buttons? You know, the fellow wouldn't want to listen to that. However, the co-pilot may not be necessarily a $10,000 jet pilot, but at least if the fellow said, yeah, I think I can keep it straight and level straight ahead while you go to the bathroom, Joe, that's what he really wants to hear. And if you can walk into a courtroom, and if a judge can talk to you for 5 minutes and determine that, yeah, this fella could probably hold this airplane straight and level straight ahead for a few minutes, he's more inclined and more apt to want to listen to you, especially if you have any skill or any ability to speak at all. And if you don't by now, let me recommend that you take up a year with the Toastmasters so that you can learn to speak and to express yourself, because all lawyers do, you know, when they get in the courtroom is to speak. And you're there to adjudicate issues. And you're there to talk about knowledge, talk about law. And the judge wants to be able to sit here and listen to you expound your theory of the law, your position in the law, your status. the essential facts and the statutes, if they apply, etc. He doesn't want to listen to a bunch of mumbo-jumbo about, well, I got, and then there's Article 1, Section 10, and I got these rights. Yes, go on, Mr. Jones. Well, it's against the law for you guys to do this, and they're taking my taxes, and I don't like, and they did, and then on top of that, and this guy took this from me, and then, you see, and pretty soon, you know, the judge is sitting on the edge of his seat saying, I got another one of these constitutional screwballs in here who's nothing but a tax protester. He doesn't have anything logical or coherent to present. And when you get into this process of the appeals from now on, you're only talking about law, not facts, because there are no factual issues now to be decided by the courts. Only issues of law and constitutional rights are going to be entertained in the appeals process. And that's why you filed all of these motions, and that's why all of these legal briefs, to outline and to set down your position consistent with your status and the facts of the case pursuant to the Constitution. And that's why you're in that appeals process. And I have yet to talk to a judge above the magistrate's level who's been rude or curt with me, to my knowledge, that I can recall right off the top of my head. There were some times when I can see some judges were a little mixed up, you know, and a little concerned about my sanity as to my position in the early days. But I notice now, a year and a half later, after several appeals have gone in and we've presented some Supreme Court decisions and cases and legal briefs, I was in the courtroom just yesterday and I noticed that the judge listened to every word I had to say, looking at me just like this, eyeball to eyeball. In fact, I thought he was almost trying to stare me down, but I noticed that he was intent upon what I was saying, which is important. That's the purpose of oral argument, and that's the purpose for going into the courtroom. There's something I want from you, Judge, and this is what it is. And here's why I want it, and here's why I'm entitled to it. All right? This appeals process, now keep in mind, is designed to weed you out. If there's one thing that the courts are attempting to do, is to get rid of you at the earliest possible stage of the game. Now, if we'll just take the traffic court as an example, how many traffic cases concerning a driver's license do you think the Supreme Court rules on every year? My guesstimate is 0. Probably the last time that a Supreme Court of the United States in any of the 50 states or in the federal Supreme Court, and possibly even the appellate courts, that is our 10 circuit courts of appeal, have ruled on the constitutionality of a driver's license was with Smith versus Thompson in 1930, which was a Virginia appeals court case. Now, for those of you that have the driver's license issue, you can take a look at the Thompson-Smith case, and you can see that it never really got very far because the court recognized early on. In other words, here's the appeals court, which is the step before the state Supreme Court, recognized that this fellow had rights and that it was a right to drive on the road and not a privilege, and so it wasn't necessary to run it up any higher up the flagpole. And you're not going to find very many United States Supreme Court cases on the driver's license because, you see, the very word license means privilege, and the High Court does not rule upon privilege issues. The High Court rules upon rights issues. There has to be a federal constitutional issue before the Supreme Court of the United States is going to listen to it. And there has to be a controversy. There has to be a factual controversy for those people to listen to your case. And so, up through Lesson 29, you should know by now that if you haven't done your homework between the scene of the crime and the time that you're sentenced and you're on your way to jail and you're trying to determine how am I going to conduct myself inside the jail now or during my period of incarceration, if it comes to that, why, what is it that I'm going to do to appeal? You know, how can I keep my train on the track to Washington? If you've done your homework, your train is on the track to Washington, and you're going to have to keep it on the track because every court is trying to derail you, so to speak. What they're trying to do is to resolve that issue before it goes any higher up the line. So, to answer that question, the Supreme Court never has, to my knowledge, decided on the rights issue of a person driving a car because since 1900, everybody's gotten a driver's license. And once they've availed themselves of the privilege of the driver's license, it's no longer a rights issue. And so insofar as the lower courts are concerned, they simply say, it's settled law, it's been settled and settled and settled and settled. I've heard this, over and over. They look at me down here and they say, Gordon, you're crazy. It's been settled. And I'm sitting here saying, well, wait a minute, this is a new issue. You see, I'm a belligerent claimant in person, and I don't have a driver's license. And I contend that the driver's license is a privilege to do something that I've already got a right to do. I'm probably the first man in the history of the United States that walked out or drove out on the street without a driver's license, took the license plates off of his car, refused to insure it, and said, okay, Officer Smedley, come on over here. Here's this first black guy driving down the middle of the street, and he isn't going to ride the back of the bus. And Smedley took my car away from me and arrested me and took me to jail. And there's the issue. I've suffered a damage. I'm contending that I have a right to do that. All right, now, to keep my train on the track, then, I've got to have, as an example, if we took a look here at this case, number 9. Now, remember lesson number 9. See how thick that is? This lesson number 9 now isn't a driver's license case, per se. But let's turn over to it as an example, and let's take a look at the rights issues that we've brought up. If you'll notice in the nomenclature, there's 38 total items that we have in here. Now, not all of those are my motions necessarily, but if you're turning over here to your lesson 9, you'll notice that there's a list of charges against the jailers and the statute on charges, then a motion for discovery under Rule 16. Now, let's take motion for discovery under Rule 16, just as an example. If you'll notice over here in the Idaho Criminal Rules, we have a Rule 16. Okay, so you flip over to Rule 16, and I sit here. This, remember, was long before the trial, and I said, how can I create reversible error? How can I make my opponents break the rules to such an extent that I can win this case with reversible error? So I went over to the discovery and inspection, and I read the rule, and I'm not going to sit here and read the rule during this lesson here because that's superfluous, and I think we've already covered this. But there were certain things set down in here. And under Rule 16, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 items. More than that. 17, 18, 19, 20, 21, 22, 23. 23 items. 24, 5, 6, 26 items. 26 things that the prosecutor had to do for me, or potentially had to do for me. I had a right to know the names of all of the witnesses against me. And so in discovery I said, I want to know the names, addresses, and phone numbers of all of the witnesses against me. It's necessary and imperative for the trial, so that when I get to trial, I can prepare the questions that I need to ask on rebuttal and cross-examination and determine whether or not I need to subpoena them in for direct examination. All right. Now, in the event that they did not give me that list, when I got to trial, it was necessary for me to set the record in cement. But, Your Honor, I object. I'm not ready to move forward because I don't have a list of the opposition's witnesses, and therefore I'm not prepared to cross-examine them, and I'm not prepared to bring them in. I haven't served subpoenas on them to bring them in as direct witnesses for the defense. And assuming that the trial judge said, that's superfluous, Mr. Gordon, I think you can proceed. This is just a simple traffic case. Motion denied. Now we'll go forward. Right away I write that down. Witnesses Rule 16. All right? Now, in here I have my discovery. Here's my written demand pursuant to this rule of the game. You know, it's like playing this game of football. And I'm out here on the field, and the opposition threw a pass. The referee caught it and ran into the end zone. And I'm sitting there saying, wait a minute, you can't do that. And the referee says, the referee just happened to be right there, and he just couldn't resist, and he caught the ball and ran in. And we're going to go ahead and score 6 points for your opposition. Well, now, if that happened on a football field, I don't know how they handle that, and I've never heard of that happening, but I don't think that they could get away with that. And the same thing is true here in the courtroom. They can't get away with that. And these lower courts do things like that every day. They just break the rules as if there were no rules there, and that's the best news you can have. I was in court yesterday, and the judge sat there and read me the Riot Act. He told me that he was going to hold me to the same standards as a licensed lawyer in the state of Idaho. I felt like telling him, thank God, I'm being held to the standards of incompetence, and for that reason, thank you, Your Honor. Now, I held my peace, and I didn't say that. But nevertheless, those lawyers are held to these standards of rules, and you're going to be held to the standards of these rules. And that's why it's so crucial that you set the issue long before you go to trial. Now watch what would happen. Let's suppose that you got into the courtroom and they brought up a surprise witness, and gosh, I didn't know that guy was going to be a witness, and then you didn't know what questions to ask, and so you asked him 2 or 3 questions, and then after the trial was over, you thought about 6 questions that were really important and probably would have resulted in your acquittal. And then you bring that up in your appeal brief and you say, but they brought this surprise witness in here and I wasn't really prepared for him and I don't think that's fair and I think they should reverse. I think you should give me a new trial. The weeding out process will come into play right there and they'll say, well, let's see, pursuant to Rule 54 and pursuant to Rule 16, pursuant to Rule 43, you didn't object timely, Mr. Smedley, and for that reason, we're going to deny you that appealable issue. You see what's happened? That's an appealable issue at every stage of the proceedings, from here to Washington. And that weeding out process comes into play at every stage, and they're going to use that weeding out process against you. Now, with Lesson 9, you now have the checklist. You've got a notice and demand for right sua sponte. You want to test that during the trial and during the proceedings. You want to find out, did the judge notify you of any significant right that you are entitled to? Did he fail to notify you of any significant right that then you could allege caused prejudice and caused you to lose a certain measure of momentum in the trial or possibly caused the jury or caused you to waive a significant right, like your right to challenge the state's prima facie case? You know, if you filed your notice and demand for your right sua sponte as an example, and let's say the trial judge, and you forgot, and at the break he said, well, it's lunchtime, the state stand, well, we rest, Your Honor, and the state rests, and the judge says, well, it's lunchtime, let's go, and you go to lunch, and you come back and stage your defense, and then the trial is over, and you say, darn, you know, I don't think they proved their prima facie case. Why, gosh, Judge, why didn't you tell me? And then you bring it up, say, at the end of your case, or somewhere in between, and the judge says, you're not timely now. There's your safety valve. Well, Judge, I told you in writing that I was a layman, and you have a duty here as the judge, the presiding referee, to inform me that I have this right at this time and that I've got to make my action now. And, Your Honor, I object to this. Okay, there's an appealable issue because of your notice and demand for right sua sponte. Let's take a notice and demand for counsel of choice. Now, you walked in there at the arraignment and you said, I've got my friend Joe Bushnell over here, and Joe is going to assist me. I don't speak too well, and Joe's going to talk for me. Say, Aaron spoke for Moses, remember. Moses was the man in charge, but Aaron was his mouthpiece. All right? There's a good example. Now, you're entitled to counsel, but you're not entitled to lay counsel to represent you. The word represent means to stand in your place or to act for you. That's power of attorney. Now, you don't have a right to that, to my knowledge, although if you were to write up a power of attorney for someone, if he could go into the courtroom and if he could speak, I think maybe it might be incumbent upon the court, but then again it may not be. And that may be new ground, and I'm not suggesting now that you take on new ground, but for the appeal process, we know that we're on safe ground because the court's already ruled in so many cases on counsel. You have a right to have a next friend sit here with you, if nothing else, to advise you and to help you. And from time to time, you may even have to speak or cross-examine or voir dire a juror. If that's the case and it's denied you, then that becomes an appealable issue. And while that trial is going on, you should be taking notes of these potential appealable issues. Now, in my case over here in this Lesson 9, to give you an example, I'd be looking for Rule 16 violations. How many times did they violate Rule 16? And here's my motion for subpoena ducis tecum. You know, they didn't bring the jail suit in, as I recall. And so without that physical evidence there, I was unable to cross-examine effectively. And so that's an appealable issue. The motion for writ of habeas corpus, I think, was superfluous. I don't think it comes into play, so we didn't win any points with that motion. Here's a notice of preliminary hearing. That came from them. I got the Breed versus Power case on what is a felony. Motion to dismiss for failure of process. Oh, I don't think that they gave me my grand jury indictment, did they, on this felony? And so I'm claiming a faulty service of process and that they're prosecuting me by information. Okay, that's an appealable issue. And remember, if you're in a state that prosecutes either by indictment or information, it was necessary for you to demand that grand jury indictment. Now, once you made the demand for the grand jury indictment and they refused or failed to give it to you, now it's an appealable issue. There's another appealable item then. A motion to produce the transcript of the hearing. That comes under Rule 5, as I recall. You take a look and you say, wait a minute, did you produce a typewritten transcript pursuant to Rule 5.2 for me? Well, did you notice it up timely prior to trial? Now, while we're talking about noticing up here, there's a new tactic or stratagem here that we've just developed, and so since it's new and it's worked well, I'm going to pass it on to you right now. We've noticed in the past that when you put an appeal in, it oftentimes dies, or what we call it being sandbagged in our district court. You appeal from the magistrate's court to the district court. The district court would then demand a transcript. The transcript cost then is, say, $500. Then they'll send you a demand for $500 before they'll produce the transcript. So here's what I did. After 3 or 4 sandbaggings, and that's after all right, because that's a victory. If they refuse to hear your appeal, then you're just sitting there in limbo. If the traffic court doesn't throw you in jail or execute a fine, you've got no cause of action under Title 42. And so you've been to trial, found guilty, you've paid no money, and you haven't gone to jail, and the district court has used the transcript issue as the excuse for not listening to your appeal. They saved some money, and you won your case. At least it's a de facto win. You went to trial, the jury found you guilty, and you paid no money, and you didn't go to jail. So the other day I got one, and it was on this Trover case. And I think I'll digress here for a moment and explain how this works. This is the Trover. That's a thick case. It took 2.5 or 3 days to try that case. And I got a notice in the mail. This is the typical sandbag. And this is the case where a police officer in Boise seized my car and my motorcycle. And they've kept it to this day. And I'm now in the appeals process. And so in order to get rid of George Gordon, they want, the district court says, how can we get this guy out of our hair? Well, they sent me a bill the other day for $1,338. That was the transcript fee. And in the transcript fee, they gave me so many days to do this and so many days to do that. And let me tell you, those days now are extremely important. And when you get a demand like this that says, pursuant to Idaho Rules of Civil Procedure, Rule 83J2C, that a transcript be prepared of all of the proceedings of the trial court herein upon payment of the estimated fees by the appellant, that's me, as provided by Idaho Rules of Civil Procedure, Rule 83K, and it is further ordered, and it goes on, you better be sitting here writing down 83K and 83J, and then you pull out your rules of civil procedure and you say, okay, now what is it that they're requiring of me? What is it that I have to produce and in how many days? Well, I found out that what I had to produce was, did they say something here? They wanted $1,338. Yeah, here it is, right here in front of me. Notice of appeal having been filed in the above entitled matter, estimated cost of the transcript on appeal is as follows. Partial transcript of a jury trial, 669 pages at $2 each for $1,338. Well, there's a limit to how much a 1965 Chevrolet is worth, even though it's a classic. And the motorcycle, there's a limit to its value. And so I'm sitting here saying, well, wait a minute. I'm going to have to pay $1,338 for the transcript. Gosh, that's like being penalized, isn't it? So I filed a motion to waive the transcript fees. Now, in a civil case, if you can afford it, you're going to have to pay it. And if you can't afford to pay it, you're going to have to show that you're a person who's indigent or poor. So I filed a motion here to waive the transcript fees. And I quoted my state constitution. In fact, maybe I'll just read it to you because it's kind of short. It says, comes now the plaintiff to move the court to waive the transcript fee in this case for the cause that under the Constitution of the State of Idaho at Article 1, Section 18, that, quote, justice shall be administered without sale, denial, delay, or prejudice. So my contention is then that the $1,338 is selling me my car and motorcycle back. And you can understand that the district court, they're burdened down by a lot of work and just plain laziness, and we don't want to listen to a dumb case like this anyway, and that Gordon's out to lunch and a dumb constitutionalist. Now, how am I going to get them then to listen to my issue, to listen to my case? So I went on to say, the issue in this case is the recovery of the plaintiff's property taken by force and violence by the government without compensation. The actual value of the property isn't much more than the cost of the transcripts. To compel the plaintiff to pay the transcript fee is to sanction the government's taking of a citizen's property by use of the police powers and then return the property when the victim can afford to pay. So I'm going to steal your car, and if you can afford to pay the storage and the ransom for it, you can have it back. And to me, I say that smacks of theft of property without due process of law. That's a violation of Snydeck versus Family Finance Corporation, remember, and that it's property. This is nothing more than theft by police powers and is in violation of the plaintiff's inalienable right to property. Idaho Code 2822-101 comes into play in this case because the dollar-cent mill are the only lawful money of account in Idaho, and the plaintiff has no lawful money. Federal Reserve notes are forbidden. Now, I want you to notice I'm beginning to raise the money issue, but I also want you to keep in mind that the money issue is not the issue here. That's a collateral matter. What I'm doing is just opening the wound, pouring a little salt in, and sealing it up and saying, okay, Judge, how's that feel? Federal Reserve notes are forbidden and may not be compelled as payment by the state for this transcript. The Ninth Circuit Court of Appeals has ruled that the Federal Reserve is a private corporation. This private corporation issues private notes, and to compel payment in Federal Reserve notes would be an action enriching a private corporation. Such an act would result in the taking of the plaintiff's property for the profit of a private corporation. Federal Reserve notes cannot pay a debt at law. A debt tendered and discharged is not paid. Cohen versus Virginia. If I have a debt, I demand the right to pay said debt at law. I refuse to discharge any debt in any maritime contract. And finally, if I were to be required to pay in Federal Reserve notes, I could not, because I don't have the amount of Federal Reserve notes demanded. I'm a pauper. I have no assets. I am without income. And I'm without a job, and there is no way I can pay the said transcript fee. Attached here, too, is my affidavit of poverty. And I put an affidavit of poverty in here and said essentially the same thing. And the document speaks for itself. Now, once I filed this, I said, okay, now let's set it in cement. So I called the judge's clerk, and I said, now I want to argue this in oral argument. So I motioned it up, and I hauled my adversaries in, and I kept 2 lawyers in court for 3 hours. Well, at $60 an hour, that cost them another $180, didn't it? Now, it cost them $180, and I went into court, and I said, Judge, I don't think that this is a mere issue which can be called frivolous on its face, because this is a rights issue. And I went on to tell the judge, if I were a corporation called Gordon's Incorporated, I would concede that I need those vehicles registered and that the driver must be licensed or that the officer might seize them summarily. But in this case, we're talking about the private property of a natural individual, and under the Hale versus Hinkle doctrine, Your Honor, you can't do that, because there's something different about a corporation and an individual. Judge says he'll take it under advisement. Now, I sit here and I say, aha, look at what the judge did here. I'm claiming rights. I need him to tell me no so that I can move it to my state Supreme Court. But I noticed an opening yesterday. He said, I'll take it under advisement. I detected that what he was saying was, I don't want to pay $1,338, but on the other hand, I can see that you've got a meritorious argument. What am I going to do? So what I'm going to do for him is I'm going to make it easy. Like any salesman, you don't have the whole $3,000 for this car. Is that right, sir? Well, let me tell you what I'm going to do. For only, how much money do you have, sir? Oh, you've got $1,000. Give me $1,000 down, sir, and $25 a month forever, and you may drive this new car off of this lot right now today. So I said to myself, here's what I'm going to do. In the entirety of this case, there's only the issues of law. There are no issues of fact for the court to decide. When the jury tried the case, the opposition very cleverly, and I admire them for their position, talked to the jury and said, well, look at this guy Gordon. He's an outlaw and a criminal. He brought all this on himself. Why, the dummy doesn't have a driver's license, and all you people have a driver's license. And this dummy, he didn't have any license plates on his car, and he just told the policeman right out, no, I don't have any license plates. So what? And he didn't have any insurance on his car. Now, you good people all have insurance on your car. And so when the jury came back with the verdict, what they were saying was, we find that the defendant, or the plaintiff rather, in this case, George Gordon, is guilty of not having a driver's license, registration, and proof of insurance, and therefore the policeman was doing the right thing when he seized his automobile. My contention is very simple. It's a matter of law. I may be guilty of not having a driver's license, registration, and proof of insurance. But the remedy for that crime is not the forfeiture or the seizure of my property. The remedy for that crime is a fine and imprisonment, but it's not the theft of my property. And furthermore, if there were going to be a seizure of the property as being contraband or used in the commission of a crime or something, it would be seized, and then it would, by judicial process under Title 37, it would then be taken by the state for the state's purposes. It would not be taken by the officer and then given to two towing companies who are two private mercantile interests.